Hi folks, I'm Greg McLawson, the Affidavit of Support lawyer. I represent plaintiffs in federal litigation to enforce the Affidavit of Support. Today I wanted to talk about how attorney fees work in these cases. If you're like a lot of folks and you have a claim under the Affidavit of Support, you may have found that it's surprisingly hard to find a lawyer willing to represent you. For some people, that's confusing because the Affidavit of Support has something called a fee shifting provision. This means that the defendant is responsible for paying the legal fees of a plaintiff who successfully enforces the Affidavit of Support. So you might think if the statute and the contract itself both say that the defendant is responsible for paying legal fees, why isn't basically any attorney just really willing to take a case under the Affidavit of Support? Well, let's talk about what the law is and kind of what it actually means in practical terms. So it is correct to say that both the federal statute, also the regulations at 8 CFR 213(1)(a)(1), and the Affidavit of Support itself, they all have provisions in them that say if you are a green card holder and you enforce the Affidavit of Support, the defendant can be made to pay all of your legal costs. That includes the filing fee, any costs associated with the lawsuit, and your legal fees. So that is true. That is in the statute and the regulations. And indeed, it is true that federal courts consistently award attorney fees in these cases. To my knowledge, no federal court has ever denied an attorney fee request to somebody who successfully enforced the Affidavit of Support. So it seems like if that is true, why wouldn't you be able to go to any lawyer in any city in the United States and say, hey, represent me in this case, and you will get paid automatically by the defendant? If you are not a lawyer and you don't run a law firm, that might sound like a really attractive proposition. But here's how it works in reality. Most lawyers get paid what's called a retainer when they start work on a case. So if you go up to a lawyer and you say, hey, I want you to represent me in this litigation, the attorney will say, I'm happy to. My rate is X dollars an hour. And to get started on your case, you need to pay me $10,000. That goes into my trust account, and I will bill against that amount of money. That's like an insurance policy for the attorney. The attorney knows that however much work they do on your case, they have the assurance of knowing 100% for sure that they are going to get paid because that money is sitting there in their client trust account. Plaintiffs in cases to enforce the Affidavit of Support can't do that because they don't have any money. Basically, by definition, if you have a claim under the affidavit, it means that your income is 125% of the poverty guideline and below. So you don't have money to do a $10,000 retainer for an attorney. So that means that the attorney doesn't have that insurance policy in their bank account to know that they're going to get paid. And instead, they are going to be reliant on the federal court to award attorney fees, not now, but down the line when they eventually win the case. So already, instead of that attorney knowing that a payday is at the end of the month for whatever work they've done on the case, that attorney has to deal with the fact that this case might settle this month, it might settle 2 months from now, it might not settle, and it might go to trial months and months from now. And so you are asking the attorney to do work that, in the best case scenario, they're not going to get paid for this month. It's going to be next month, the month after that, or maybe a year down the line. So already, that's a very different proposition. Imagine if you go to your work. Imagine you go and work in a restaurant, and the employer, instead of saying, hey, I'll pay you in 2 weeks, says, I will pay you 6 months from now or a year from now. That's a much less attractive proposition, isn't it, than knowing that you are going to get paid for the hard work that you did at the end of 2 weeks. And law firms are the same way. A lawyer is going to be less enthusiastic about getting paid in 6 months or a year for work that they're doing in the meantime. That's part of it. The real kicker, though, is that any award of attorney fees is like a judgment, which is to say that there's no assurance from the universe that the attorney is going to get paid. If you get a judgment against a defendant for $40,000 or whatever it's going to be, that doesn't just magically get paid. If the defendant puts up a fight, you have to use involuntary collection measures like garnishment or foreclosure to collect the money from the defendant. This doesn't just happen. So a scenario that the lawyer is going to be thinking about is that 6 months down the line, I get a judgment against the defendant. I've done all of the work. I've won the case. I've done everything I was supposed to do. The federal court has done what it's supposed to do, which is award attorney fees under the statute. So now I have an attorney fee award, and the defendant just won't pay it. Well, then that attorney is going to have to do a whole bunch more work to make sure that the defendant actually gives the money over in the form of a garnishment or foreclosure, whatever it's going to be. So that's a whole substantial additional set of work and risk, because there are all sorts of bodies of law that weigh in on how a judgment can and cannot be collected. So if the defendant puts up a fight even after a judgment is issued, the attorney has a risk that the fee award might not be collected again for a long period of time after the judgment is issued. So you might have a year before the judgment is issued for the attorney fee, and then another year before the attorney gets paid, or even a lot longer. So that's one of the reasons that when you go to an attorney and you say, hey, I've got this claim under the Affidavit of Support, would you be willing to represent me? There's an attorney fee provision. That might sound really good, but the attorney knows what the reality is actually going to be when it comes to enforcement of attorney fee awards. That lawyer might be looking at months or even years before they get paid for their work. And that's a less attractive proposition for attorneys than simply knowing that they will get paid, just like you want to get paid when you go to work and have a paycheck coming in 2 weeks. At my firm, we went into this area cautiously. So I've been doing this for over 10 years now. At first, we were very concerned about whether we could consistently get paid for our work in that scenario I was just describing. Having done a bunch of these cases, we now know that we can, but we have that confidence only because we've done enough of these cases. If you have questions about a claim under the Affidavit of Support, you're welcome to reach out in the comments. I'm happy to answer general questions there. If you would like a confidential assessment of your claim under the Affidavit of Support, you're welcome to reach out on our website. We do free Zoom consultations all across the United States. Happy to set one up. Hope this is helpful, and have a good week, everybody.